Once again, Callie Wright is going to take you through the legal panel.
Hello again. So as before, I think we'll just go through and we'll have our panelists introduce themselves. Obviously, you just got done hearing from Andrew.
I don't need to go.
All right, my name is Shelly Henry. I'm an attorney in Louisville, Kentucky with Craig Henry PLC. We represent individuals in employment disputes as well as organized labor.
You guys are already sick of me. I'm Dan Cannon. I'm a civil rights lawyer and a professor of law at the University of Louisville Law School.
So I feel like my first question I think should be the same as it was for the sex education panel. I'm interested, obviously, like there's the joke about how everybody hates lawyers, but honestly, especially in a movement like this, sometimes the lawyers are actual, like the unsung heroes of the movement in advancing positive change. And so I'm curious what each of you sees as the biggest challenge that you face in, especially a context like this, and church-state separation, that kind of thing, but just in the general work that you try to do towards making things more positive in what you do, especially in the legal profession.
Well, yeah, I think.
Click it on, please. I think there are a couple different challenges. One, there's a current attempt to weaponize religious liberty, to redefine what religious freedom means, to turn this into a license to discriminate. I think that is a big issue that we are dealing with. The Arizona Supreme Court just decided a case in the wrong direction on that very issue after it was packed with two extra Republican judges. That has been an issue that's been going for at least a decade that we've been fighting against. The erosion of the wall of separation between state and church is a second big issue. I mean, you're seeing it in cases like the Bladensburg Cross case that came down, the Trinity Lutheran case that was a couple years ago. That is really critical, and we're seeing the court using really bad history and elevating history over legal principle to decide these cases, which is frustrating for somebody who's written a book on American history and the law to see. Those are kind of the two big things for me, but I also think it's critical to realize that the courts are not often these vindicators of civil rights, these bastions, these defenders of civil rights that we hope they are. They are often lagging behind the rest of the country. One of my law professors likened the Supreme Court to the last person in on an all-team tackle. Right? Everybody's piled on top of the ball carrier, and then the Supreme Court comes running along and jumps on top of the pile and says, "Look what we did, we're the best, yay." But they didn't really affect any change, I think with the exception probably of the Warren Court. That is kind of our history. So conceptualizing that we may not win this fight in the courts, we may win it with demographics is also an important thing.
So I will say on a much more local level, the biggest challenge is people understanding that we do have a state law. Kentucky has a Civil Rights Act that is actually very, very good, but people just don't know about it. And it does include protection for against discrimination or hostile work environments based on religion or the lack of religion. And so there is a case that can be made if people are experiencing religious discrimination at work. But a lot of folks don't know that. A lot of managers don't understand that there is protection there for non-believers. So those are a couple big things. The next thing is just finding a lawyer who's willing to take those cases. And generally when people get to me, they have contacted multiple lawyers who weren't able to help them, and it's taken a lot of time for them to actually get to me. And we can help in certain circumstances. So that's a couple of big things. The other issue is our judiciary. These are oftentimes going to be federal cases, and we have a bunch of Republican appointed judges in the Western District of Kentucky as well as the Eastern District, although we practice mostly in the Western District. We had one last great judge, comparatively, and we're about to lose him too. So that's probably the biggest challenge locally.
I appreciate the characterization of lawyers as unsung heroes in these battles. I'll challenge it though by saying I think we're a little too sung, and I think what Shelly is saying and what Andrew is saying, is that the courts are not going to save us. And that is, that's tough when you're working within the courts and you're using the courts, you've conceptualized, like I have for my entire career, as the courts being this tool of social change. Not really, right? When you look at it, not really. And I don't think it's our most effective course of action on just about any social issue that you can think of to advance the ball forward. So I think we have to get out. I think the challenge for lawyers especially is that we get out of that mindset of, these top-down solutions being our best way forward, and that these movements are going to be led from the courts by lawyers, and that's how social change happens, because that's the way that we tend to learn. How we sort of romanticize the Warren Court era and that whole thing, and it really, I don't think that's our way forward. If anything, the last couple of years have taught us anything, I think bottom-up strategies are much more likely to be successful going forward. We need to figure out how to best provide support, get out of the way to an extent, and best provide support for those bottom-up movements that we're seeing that don't involve the courts or what we think of as traditional change-making institutions at all.
Yeah, that actually dovetails super nicely into my next question, because if, so like Andrew was talking about how we are seeing, like, we're losing some of these fights, right? And obviously that doesn't mean we stop. So where do you see your profession fitting into that? Like we have the arguments on October 8th in front of the Supreme Court about the employment discrimination, about trans folks and gay folks. We have a big fight like that, like the cross and all of that. What becomes your role in that once we lose those cases? Like, what is, because obviously as a harm reduction strategy, we try to prevent bad rulings from happening, right? But being more proactive and trying to push positive things, or dealing with, like, the courts have ruled badly and now we have to figure out what to do. What is your role in that?
I just talked.
Yeah, I mean, well, when you have a loss like that, I mean, the first thing you have to do is try to stop the bleeding and look for ways that ruling is going to affect your other cases. And for instance, in the Bladensburg cross case, and just to back up for a second for people who don't know, this is that 40-foot tall Christian cross just outside in Bladensburg, Maryland, that was recently upheld by the Supreme Court. They upheld it because they said that, it's a Christian cross, but it's also totally got other meanings behind it.
It's a secular cross.
Secular symbol, too. They said that we couldn't know what the people who put the cross up 90 years ago were thinking when they put it up. We could never know that. But we definitely know what the founders were thinking 230 years ago. It's a terrible opinion. Anyway, I mean, it is affecting a number of other state church cases, and we as a movement have suffered a number of other losses where courts are citing that. So the first thing you have to do is kind of stop the bleeding and try to limit the damage of that case when it happens. Not that case, any case when you get a bad ruling. But I mean, right now. Let's try not to be doom and gloom the whole time.
Okay.
But the courts are very, very bad right now, and so you also, while you have terrible courts, you're trying to lay a strategy that can be adopted when the courts are less unfriendly, and get legal reasoning and reasoning that's friendly to our positions into opinions, even if they are dissenting opinions in a loss. That can be adopted later on when terrible decisions like the Bladensburg Cross decision are overturned, which I think will happen given just how, it was just such a bad opinion anyway.
So I think that one of the best things we can do when we get these really horrible decisions is start working as activists on a state or local level. For example, no matter what happens on October 8th, Louisville still has a fairness ordinance. A lot of cities in Kentucky do. We can continue to embrace that and push that into other communities. And we can encourage our legislators to add sexual orientation to our Kentucky Civil Rights Act. So there's a lot of things we can do. I know that I worked with the ACLU a little bit over the last year on this In God We Trust bill, and the In God We Trust in the schools. And between ACLU and I work with the Americans United for the separation of church and state, we sent out lots of calls for people to call their legislators about that bill. And there was some response. But the ACLU got so many calls when it went into effect and all those stories were on the news They said to me, like, where were all these people when we were asking them to call their legislators? So that's one of the big things that we can do. We have a really short legislative session in Kentucky. It's not hard to make those phone calls, and we just need to really be proactive about doing that, and then also working on our local level to have these local ordinances that protect people.
I would also like to remind everyone, as before, questions, note cards and pens. If you want to write something down, raise your hand, and someone will come grab those from you. So.
No, I was just going to say, real quick, going back to what I was saying before, I think we don't really know the answer to your question. You know what I mean? In terms of how we don't really know how to. I think that lawyers, lawyering, advocates as a profession have been sort of stuck in this mindset of we are going to lead the charge through the courts, and that's how we're going to make change. I think we have to reevaluate that. I mean, I think there needs to be it's kind of what Shelly was saying, there needs to be a wholesale reevaluation of how lawyers operate within social movements. And I think a lot of it involves us getting out of the way and listening to the people that are most affected by oppressive laws, by bad stuff in society, generally speaking. And getting out of the way of those kinds of things is not something that lawyers are very good at. Gabriel Arkels, who is arguing at the Supreme Court, or he's part of that team on the Supreme Court for the case on October the 8th, has written a lot about this and about what a lawyer's role ought to be in a world where the courts really are not going to be the sort of bastion of social change that we like to think of them as.
And what is your role in that? I'm curious. So we talked about a little bit about how figuring out the bad decisions. So obviously getting out of the way and letting activists try to get good laws passed and that kind of thing. What is an attorney's role in pushing for positive change? If not, like, we're not using the courts as a tool to do that. What do you guys do?
I mean, I think again on this very local level, and Andrew, I'm sure will address it more nationally, is really helping folks figure out how to be advocates at their local and state level. And we can help you with that. Like, we're used to dealing with these laws. We know how they're written. We know that process. And I think almost anyone in the group that would be interested in this is more than happy to meet with any group to talk about how laws are made. How do you contact your legislator? What's the most effective way? I think that's something that we can do.
I mean, and we can operate within a sort of grander legal strategy. I mean, but it all comes back to we have unfriendly courts right now. And what do you do? So the other side, for instance, if they are trying to erode the wall of separation between state and church, and let's say they want to eventually get a ruling from the Supreme Court that says religious groups or churches or religious schools have a free exercise right to taxpayer funding. How would you go about doing that? And the way you would do that would be looking for these incredibly sympathetic cases, like a case involving kids and getting their knees skinned on a playground in Missouri, and that became the Trinity Lutheran case. They set up in front of the Supreme Court one of those plastic play school slides to argue this case. And they won it because they had this very, very sympathetic plaintiffs, and they were taking small chips out of the wall of separation. And there's another case coming up right now out of Montana, a neo-vouchers case called Espinoza, that the court should never have taken, but they're going to right now. That's the next chip out of that. So there is a role, I think, for us in sort of a grander strategy on the back end, but all of that really still depends on having courts that are going to listen to these strategies when you get before the judges, which again depends on friendly judges.
There's another piece of that too, where I think, and I tell my students all the time, there's two ways to make change, and one is to stand on the outside of the machinery of government and bang on it and demand that it change course. And then the other way is to hop inside the machine and steer it where you want it to go. And lawyers necessarily fall into that second category. Like, we're necessarily part of the machine. We're necessarily part of the system, no matter how, much sort of anti-establishment we want to think of ourselves as being sometimes. And so, but I think that there is a role to play for us in sort of bridging that gap between the people that are on the outside of it and the people that are on the inside of it. The people that know how to negotiate state stuff between state agencies and the courts, and the kind of things that happen on the inside of the system. And a lot of the folks that are most marginalized are not able to do that without lawyers. So as long as we are putting them front and center and sort of helping them get to where they actually need to be and not where we think they need to be, I think that we have an important role to play in that.
So an audience question I think is a good one. Can lawyers help draft model legislation? And if the answer is yes, could you give some examples?
Yes. And now for the examples.
Yeah, I mean, we do this all the time. We have a couple of different bills that we are looking at. I mean, almost all the secular groups here have at least one lobbyist on Capitol Hill who are working behind the scenes, who you really don't hear about, who work to push these bills. And they run the gamut. I mean, one that's gaining traction is the No Ban Act. There's a couple different bills that are working to undermine the Religious Freedom Restoration Act, either overturning it altogether or removing the provisions that would allow people to discriminate using the Religious Freedom Restoration Act, that's the Hobby Lobby case for anybody. So I mean, that is something we certainly do all the time. I mean, I think you have to be a lawyer to write a law.
I will add, as a private practitioner, I don't really do that, but that's what FFRF does, Americans United, American Atheists, and that's what the money that you pay in memberships and donations funds those people that you don't see, those lobbyists who are out there in the state houses and on Capitol Hill. That's what they're doing, and it's such a worthwhile investment.
So another audience question, is Lemon dead in light of Bladensburg? What's the new rule and how do we fight in that framework?
Stu.
For people who don't know, the lemon is not a fruit, or
I mean, it is a fruit.
I mean, it is, yes, it is a fruit. Not in this context. It's referring to a case called Lemon versus Kurtzman, which was ostensibly the Supreme Court's test for determining whether or not a government action violated the First Amendment's Establishment Clause. And it was this three-pronged test. Essentially asked, what was the government's purpose behind this action? Did it have a religious purpose? What was the effect of the government's action? And did it entangle the government with religion? And that was the way the court that was the test the court set out to analyze these questions. And the court set it out, and then it kind of stopped using it. It stopped using it in cases where the Lemon test would have dictated a politically unpopular decision. So for instance, in 1983, there was a case called Marsh versus Chambers, where Ernie Chambers, a state legislature, challenged the chaplain delivering a prayer at his state legislature. And the Supreme Court looked at this case and said, yeah, we're not going to apply the Lemon test. We don't forget about that. Our country's been having prayers since the beginning. In fact, since before we were even a country, in 1774, the Continental Congress had a chaplain, a guy named Jacob Duché, who delivered a prayer. I talk about him in my book. He was a traitor, a complete traitor to the American cause. Okay, that's the first. Justice Alito cites his prayer in the Bladensburg case to say, yeah, we can totally have a cross because we've had prayer for this long. All right. Anyway, point being, they threw out the Lemon test and said, we're not going to use this. We're going to look at history, and we're going to decide the answer to this legal question based on U.S. history. And then they pick and choose the convenient parts of U.S. history, the fact that the prayer was said in 1774, way before there was a Constitution, to interpret the First Amendment to the Constitution that did not exist at the time. Okay. Anyway, so the question is Lemon dead? That's Lemon. Lemon's been unpopular with the justices for a long time, and when convenient to reaching a decision that they want, they've put Lemon aside anyway. So I don't know that Lemon has been alive for a very long time. Bladensburg did a number on the lemon test. I mean, it got hit really, really hard. I think one of the most recent decisions cited Bladensburg said if they didn't kill lemon, it put lemon on the shelf. So I don't know. And to answer the question, what's the test now? That's even harder because the court didn't really give us a lot of clarity on that. But I will tell you that the way other courts have been using Bladensburg to interpret it is they are looking at history. There was a case that FFRF had going in Pennsylvania where there was a seal that included a Christian cross. They said, hey, you know what? That seal's been around for almost 100 years, so it's fine. It can stay. They're using history and long-standing violations of the Establishment Clause to justify other violations of the Establishment Clause, in my opinion. I got a law review article coming out on it. You can read it.
Well, just to add to that, so I think the lesson there is if something is a problem, if there is a cross in your, some new, I don't know, city logo or whatever, challenge it immediately.
Yeah.
Don't allow history to accumulate. Like, even if it doesn't change, register the complaint so that it is clear that this has been a problem from the beginning so that we can't rely on history. Everyone thought it was okay. It's no big deal.
Yeah. Can I just add?
Yeah, go ahead.
Yeah, just to add to that real quick, that absolutely do that. And if you are unwilling to do that or unwilling to stand up, report it to FFRF. Go to just ffrf.org, legal, report a state church violation. We will take it over. We will keep your name confidential. We will fight to make sure that it is challenged. We get between 4,000 and 5,000 of those complaints every single year. Shelly's worked with us on some of those that become cases. So definitely do that. I mean, it is absolutely critical to challenge these at the time that you see them. If you let them go, they are going to be upheld in court.
So this is a great audience question. So Kentucky recently enacted the law that "In God We Trust" has to be displayed in public buildings, and so there's been a lot of talk about ways that both subtle and overt people can fight that. Can you give your perspective on that?
I'll let everybody else go first because I'm gonna be long-winded on this.
Oh, okay. Well, I mean, I think that Jefferson County and Fayette County have done a great job. I suspect there are other counties that have done
Can you talk about their approach?
Sure. So in Jefferson County, they have like a kind of a poster that has "In God We Trust," but it talks about the history of it. In Fayette County, they did the enlarged dollar bill, which I guess last week they changed to include more history instead. I think another district enlarged a penny and put that up. So, I mean, the districts are required to do this. They can't not. And appreciating that, they have done, I think, at least some of them have done a very good job of complying with the law in a way that is not Christian. So I think that's really good.
Because there were, and to be clear, the reason why they were able to do that is because there was no prescription in the law for how the phrase has to be displayed.
That's correct. It just says it has to be displayed. So right. So the problem though is that in some districts, I don't know, maybe let's go to Knox County. It is an entirely religious like the schools are a religious organization down there, and so they have really embraced it, and now they've embraced that with the Bible literacy classes, and it has just become even more of a Christian school than it was before. So there's obviously ways of challenging that, but the biggest issue, and I'm sure Andrew will touch on this, is that we can challenge that, but we can't do it without a plaintiff. And it's really hard to find a plaintiff for a lot of reasons. It's to some degree dangerous that to be the plaintiff, to be named in those kinds of cases, because people often do get death threats. They may have damage to their, vehicles if they're down there being a plaintiff or their attorney in the case. For example. So we want to challenge those, but we can't do it without a plaintiff, and we realize that it takes a very brave person to do that. But that's what we really need to really launch a good challenge to those kinds of things. So.
I also think that we should keep in mind that there's two different strategies that you can pursue even through the courts, and one is the federal route and the other one is the state route, and the state constitutions can sometimes provide you with more of a possibility for relief than going through the federal courts. I mean, the federal courts in Kentucky are awful. The state courts in Kentucky are also awful, but when you get to the United States Supreme Court, and you pretty much know that you're dealing with, well, you know what you're dealing with, right? I'm not going to say too much here. But the Kentucky Supreme Court right now in its current configuration is pretty good, and I would trust them actually more with these social issues than I would the United States Supreme Court. So, it's something that I think a lot of practitioners don't necessarily think about, but that's just going the state constitution strategy might be a good litigation strategy too. Of course, you don't get your attorney's fees at the end, so that's a problem. But we really ought to be thinking more about grassroots strategies and getting the right people elected and building movements on the ground than we should about these top-down strategies.
Yeah, certainly agree on that. I think this is a very good place for local groups and local activists to get involved and challenge these kind of things without necessarily going to court. I mean, a couple things that are really important to keep in mind. One, this law is part of Project Blitz. And talking to everyone you can about Project Blitz and explaining that this law is part of an explicitly Christian nationalist legal agenda is absolutely critical. And going into the history of the law, which some of these school districts are doing, I think is also really critical, because this is an exclusionary motto. And it was meant to be that way. I happened to go over all of the history of it in my book. But I also, you don't have to buy the book, I wrote a 3-part series for Rewire News about these mottos and about how they're tied to Project Blitz, which that's a very easy thing for you to share with your principals and your teachers and your superintendents, the history of the motto, and then why courts have upheld it. Which there's this rank hypocrisy you see in the way some courts have upheld this. Essentially what they've said is that through rote repetition, phrases like "in God we trust" have lost all their religious meaning. Now pause to appreciate, imagine if a secular court organized under our Constitution had said that John 3:16 had lost all religious meaning through rote repetition. What would be the outcry from the Christian nationalist movement, and rightly so, frankly. So there's a 3-part series on Rewire, which is very easy for you to go find and read and share with people who are in places of power. But I really would encourage you as local activists to get involved here. This is a great spot to do that and to educate on.
Cool. Well, and that is time. I know there were good questions here. Panelists, are you available for folks to talk afterwards if they have questions? Because there's good stuff. Unfortunately, we just don't have the time to get to all of it. So thank you, friends, for your time and insight.